Hello everyone, I am Anuj Jaggi and I am a legal intern with LEXIS and Company, and the topic for today's video presentation is the Arbitral Tribunal. So under section 16 of the Arbitration and Conciliation Act, it talks about or it gives exclusive jurisdiction to the Arbitral Tribunal to rule its own jurisdiction. Further, in section 7, under section 17, it empowers the Arbitral Tribunal to order interim measures. So the arbitral tribunal has to follow a procedure or has to adhere by a certain procedure which is mentioned under section 18 of the Arbitration and Conciliation Act whenever it's dealing with any two parties in dispute and who are looking for arbitration. So section 18 provides for a fair trial by an impartial tribunal. It ensures that the parties are treated with equality and each party shall be given full opportunity to present its case. Further, section 19 gives default power to the arbitral tribunal to conduct the proceedings in the manner it considers appropriate or fitting, including the dismissibility and the admissibility of the matters involving in the case and all the relevant facts attached to the case of both the parties. The important concept under the arbitral tribunal is that arbitral tribunal is not to be confused with a court. Arbitral tribunal is not a court. This is quite an important concept. And under Anand Prakash versus Assistant Registrar Cooperative Society, it was held that an arbitrator is not a repository of the judicial function of the state. He can't be compared to a court or a judge. An analogy of the arbitrator with the courts is neither required and nor appropriate. Section 2, Clause 1, Sub-Clause E of the Arbitration and Conciliation Act, court means the principal civil court of the original jurisdiction and includes all the High Court in exercise of its ordinary original civil jurisdiction. Under the unilateral model law, court in Article 2, Clause C, court is a body or an organ of a judicial system of a state. Further, definition in 1996 Act has three parts. The first one being the denotation, the second one being the connotation, and the third one being the exclusionary part. Then there comes the concept of the meaning of the word means. Means is a term of restriction, while the word includes is a term of enlargement, and when both the words means and includes are used in conjunction to define the term, the intention of the legislature is to supply a restricted meaning to the term. In the important case of the Sundaram Finance Limited versus M.K. Kurian, the Division Bench of Madras High Court, while interpreting Section 2, Clause 1, Sub-Clause E of the Arbitration and Conciliation Act, stated that the definition of court in Section 2, Clause 1, Sub-Clause E of the Act is a hard and fast definition as legislature by using the words means and the word includes indicates that no other meaning can be assigned to this expression as defined by the statute. Principal civil court means the civil court of the district judge in a district and only one district only. This was held in the case of Ankati Satyamaya versus Salangula Ilaiya. And the expression district judge includes additional district judge also. The subject matter of the arbitration, which was given under the Bharat Aluminium Company versus Kaiser Aluminium Technical Services. The court held in this case that the subject matter of the arbitration should not be confused with the subject matter of the suit. With the term subject matter under the section 2 clause 1 subclause E of the Arbitration Act has a reference and connection with the process of its dispute resolution. Its function is to identify the courts having supervisory control over the arbitration proceedings. So this was the concept of arbitral tribunal given under the Arbitration and Conciliation Act, and I hope I was able to explain to you guys the basic concept behind it and with the relevant case laws. So, thank you.